Hello, everyone. We are admitting people one at a time. Please give us just a moment. We'll begin. We hope everyone's doing well and everyone's safe. Okay. I'm going to go ahead and begin as Jennifer is going to monitor and allow more participants to enter in. We will have everyone muted as usual to minimize background noise and disturbance, but we have opened the chat box at the bottom of your screen. Please feel free to post your comments or questions here during the presentation, and we will open the dialogue at the end for the Q&A session. Also, for those of you who join us regularly, I just have a few announcements. First, we would like to invite you back to the next scheduled Lunch and Learns. The next currently scheduled Lunch and Learn will be Wednesday, August the 12th with Kelly Knowles at Bass, Berry & Sims. And her topic will be Achieving Goals for 2020, Color Coding Life. Again, that's August the 12th. Our following scheduled L&L will be Wednesday, August the 19th with David King at Polsinelli. And his topic will be COVID-19's impact on the healthcare system with respect to insurance coverage and payer disputes. Again, that's August the 19th. Please be sure to RSVP once those announcements are emailed out. Secondly, we will be providing CLE certificates for today's attendance. If you should need one, please email Jennifer Mustaine and she will certainly provide you with one. And she'll be sure to post her email down in the chat below. Most of you already have that, but just in case we have any new attendees. Lastly, this presentation is being recorded and will be available for future reference via YouTube and Facebook if you are interested. That being said, I would like to introduce our guest speaker. Lucas Elliott's law practice focuses on intellectual property, commercial and complex tort disputes in federal and state courts. His clients are in industries such as oil and gas, energy, entertainment, telecommunications, e-commerce, real estate, and insurance. Lucas graduated from Tulane University Law School and is a member of the law firm Frost, Brown, and Todd, LLC here in Nashville, Tennessee. Please help me to give a warm welcome, round of silent applause. Thank you very much, Lucas Elliott, for joining us. Welcome. We're so excited to hear your presentation today.
Thank you, Amy. Well, I hope that you all enjoy this. I moved to Nashville 2 years ago. I practiced in Houston for 30 years, and where I come from, the Deepwater Horizon litigation is still a hot topic of discussion. People are fascinated by the case, want to talk about what happened. There's, of course, tremendous lessons learned, to be had from it, and it's impacted the oil and gas industry, even a decade later, everything from regulations to how companies handle drilling operations now to other things. So I hope that for you all here in Nashville, you find this interesting. What I thought I'd do today is spend part of the time talking about just what happened, which everybody wants to know, sort of how did the well wind up blowing up, and then spend a little bit of time. I know that recently some of the presentations you all have dealt with things like social media, emails, etc. And so this is one of those cases where some of the big lessons learned are how not to talk to the media and present your case if you're BP, and how not to draft company emails, as you'll see at the end. So anyway, with that, as you all probably know, the Deepwater Horizon Deepwater Horizon accident happened on April 20th of 2010, so a little over a decade ago, and it was the largest environmental disaster in the history of the world. The accident killed 11 people, two for a company called MI, which was my client, and the other 9 from Transocean. Basically, all of the Transocean drilling crew that was on the job at the time of the accident were killed. None of the 11 bodies, unfortunately, were ever recovered. And so fun, I shouldn't say fun, it's not a fun fact. On the anniversary of the death of these poor gentlemen every year, the families go out on a barge to the location and they have a service out in the water for them as a remembrance. There were also 17 people on the rig who were seriously injured, and there were others who had minor injuries, but there were 17 who had, you know, pretty serious injuries who survived. Millions of barrels of oil, of course, were spilled over the next 3 months, and it took almost 3 months to the day before they were finally able to cap the well after you know, multiple attempts. So the just to give you some background, the parties involved in the drilling of the Macondo well were BP. Everyone knows about BP. They were the majority owner and operator of the well. They had two silent partners, Anadarko and Moex, who actually owned combined, I think, 35%. But they were not in charge of the actual drilling operations. They were not giving any directions to the Halliburton, Transocean, and other companies out there. So their role in this case was much more passive. Transocean was the drilling rig contractor. Transocean actually owned the Deepwater Horizon rig. And it was their crew members who were the ones in charge of actually drilling the well, the overall drilling operation. Halliburton, we're going to talk a lot about Halliburton today. Halliburton was the cementer as the contractor. And as you're going to learn in a little bit, it's the cement is what caused this. It was the failure of the cement job at the end of the well that caused this incident. They were also the mud logging contractors. So they were, not only were they responsible for the cement operation, but they were also responsible for monitoring some of the well activity, which also went bad at the end, as we're going to talk about a little bit. My client, MI, was the drilling fluids contractor. We provided the drilling mud and lost circulation material and spacer material that was used in the drilling operation. And you're going to hear about that in a little bit. Weatherford provided some of the downhole equipment, one of which, again, failed, and is the reason why ultimately you're going to hear the cement was out of position. It's because there was a piece of Weatherford equipment that failed downhole. And in Cameron, you may have heard quite a bit about them during the post-incident. Cameron manufactured the blowout preventer that failed and failed to seal the well when the blowout started. So those were the major parties involved in the actual incident, as well as in the litigation that flew from that. So as I kind of mentioned, the big picture background, you know, BP had taken a 10-year lease out on this Macondo site and was in the process of finalizing the drilling of the Macondo well. Now, what's interesting is that the drilling had actually started in the previous fall of 2009 with a different rig. It wasn't the Deepwater Horizon, it was the Deepwater Marianas that Transocean was using. And again, this case you're going to hear about, and as you're going to hear over time, this case is truly the perfect storm of things going wrong. I mean, absolutely, there is a series of things we're going to talk about today that happened that at any point in time, had they not happened, this incident would not have occurred. And the very first thing in our perfect storm is Hurricane Ida. So Hurricane Ida comes along in 2019 and damages the Marianas rig. And as a result, the Marianas, they close in the drilling that had been done to date at that location. They take the Marianas off site and they move the Deepwater Horizon into position and have it continue the drilling operation. So instead of, at the time of this incident, if you fast forward, instead of the Marianas crew being the ones doing the drilling, it was the Deepwater Horizon crew. So, you know, first, right out of the box, you know, arguably the first thing that went wrong was that the particular crew involved would not have been there, you know, but for the fact that there was the hurricane, you know, 6 months earlier that damaged the other vessel. Because of the delays occasioned by the hurricane and some other things, the well was very late in terms of production, in terms of getting to bottom for exploration. And you're going to, as you probably have heard before, and you'll hear throughout this, you know, time is money. There was a lot of pressure on BP to get this well drilled to move on. for those of you who are not familiar, again, with offshore drilling, especially like this in truly deep water environment where you're drilling in water that's 5,000 feet or more deep, it costs over $1 million a day during the drilling operation, between the rig, the personnel, everything else that goes involved. So every day that BP is drilling this well beyond the date that it should have been completed, it's costing $1 million. So, okay, number one. Number two, the other thing that was driving this was BP had another lease in the Gulf of Mexico with the government that was set to expire in early May. And the way these leases work with the federal government is you get a lease to, a plat of land, and you have to begin drilling operations within the time of the initial lease. If you do begin your drilling operations, then the lease continues. If you do not, however, the lease reverts back to the government. And we're not going to go into detail today, but just so you know, again, as we go later, why did they not take more time? Why did they not, do things slower, as we're going to get into some of this? The reason is because BP was desperate to get this well finished so they could move the Deepwater Horizon to another location and begin drilling operations in this other lease, which would then have triggered the continuation of that lease going forward. There are documents I'm not going to show you today that show that BP was just panicked about the fact that if they couldn't get this other lease started, I don't remember the exact date in May, by that date in May, they were going to, the government was going to take the lease away. And so that was, again, another overriding driver here, was not only just in general the cost of this well and getting it completed, but also getting it done so they could move on. So as we're going through the final days of this, all of the decisions that are being made are in part being made to save time so that they can move on to the next site. Now, I got to digress for 1 minute and talk about cement. So, because everything else I'm going to talk about will make no sense to you if you don't have at least a little bit of understanding of what happens. So when you drill drill a well like this, you have exploration and you have production. This was an exploratory well. So it's not like television where they drill a well, all of a sudden the oil comes out and then you cap it and you keep working. You do these in phases. So the Deepwater Horizon's job was to drill into the dirt, put in place what they call casing, tubing all the way down to the bottom of the well. When it's finished, when it gets to the bottom, cement in the well so that you cap it off, you basically shut it down, and then you move on to another location. And then when BP is ready to start taking the oil out for production, they bring a different kind of rig in place, and they go down, they drill down to the cement, they drill through the cement and get rid of the cement, and then they start sucking the oil out. So this is at the exploration phase. They are now finishing the well, the drilling of the well. They have now put all of the pipe down to the bottom, and they are now in the final days, and it's all about cementing in the well, closing in the well. Because they're operating, in this case, they're operating about 20,000 feet below the surface, 5,000 feet of water and about 15,000 feet underground. There are tremendous pressures and heat, down there. So when we talk about cement, it's not the kind of cement you and I are used to. It's obviously a very different kind of product. And they have to use materials that, number one, will wait hours before they start drying. You can't obviously pump this material 20,000 feet down and have it drying as it's going down. It has to get in place before it starts to dry. So there are various chemistry factors to take into account the heat and the pressures down there. Again, the kinds of materials that are used or things that you're with. Halliburton decided for this well, the Halliburton was the cement contract. Most people will call an experimental nitrogen foam cement. other types of conditions, but had not been used in this situation. I've popped up something here to show you, show that their own internal documents confirm that material should not be used in this environment. In charge disagreed, believed that it would work. One of the most damaging things to Halliburton in the case was, in discovery, it was confirmed that Halliburton did 5 different tests of the cement in the laboratory setting before pumping it. All 5 tests showed that the cement was unstable. Halliburton never got a test result, a pre-accident, that showed that this would actually work. Despite that, the Halliburton engineer kept discounting the results and kept believing that, well, in the real environment, it would work. Never did. Post-accident, Halliburton did 2 additional tests, purportedly, that they claim showed that the cement was stable. However, with regard to the first post-accident test, they destroyed the documents relating to the test results. So no one was ever able to confirm what the test results showed. And in the second one, they did not keep the test results, or keep the records of the test results. So although Halliburton tried to claim in court and with government officials that their post-incident testing of the cement proved it was stable, they never produced anything to show that it was. And you'll see later, they were actually found guilty of, criminally guilty for destruction of documents, destruction of information as a result of this, of that. But so with that backdrop, we're going to go to the next thing, which is the series of things that went wrong. And so so this is the day of the incident. Over the course of the day, the accident occurs at was it 8:30 and 8:45 at night on the 20th. But early in the morning, so right after midnight on the 20th, they finished the job. They finished pumping the cement, and they believed that they were done. After you finish the pumping the cement job, as we're going to go through in a minute here, you go through a series of tests to make sure that the cement is in place and that the cement has sealed completely. And what we're going to do is go through each one. I'm going to go through each one of them with you to tell you why they failed. And keep in mind as we go through these, again, that at any one of these mistakes that I'm going to talk about, if they had made the right decision instead of the wrong decision, this incident would not have occurred. They would have caught it at that point in time. I don't have the slide for you, and I couldn't find it. It's been so many years now. I wish I had it. The government in the trial, the government prosecutors had this great slide. And if you can envision about 6 or 7 slices of Swiss cheese up and down, okay? And each slice of Swiss cheese represents one of these decisions, one event. And imagine each one of them has holes, but the holes are not all in the same place. And so what they do is they take an arrow from the left and they go through the first hole on the first piece of Swiss cheese, and then let's say it hits a wall on the next one, okay? And then so forth and so forth. Except in one place, there's only one place on all of the slices where the hole is the same and the arrow goes through. And it was I got to be honest, it's the best piece. It's the best single visual I've ever seen in 30 years of practicing law to explain what happened here. That everything had to line up exactly in that one line of events to get from beginning to end. Otherwise, at some point along the way, you would hit a wall. But what happens here is, so the first mistake that was made is BP decides not to run a cement bond log. And what that is basically is you after you do the cement job, you shut down operations, you take a tool that they take and place down the well, and it gets to the bottom, and using X-ray and other technology we need to get into, it can actually tell whether the cement is solid whether all of the space is covered, how deep it is, etc. So think about, just sort of imagine in your mind sort of like an X-ray of the cement at the bottom. My other client, Schlumberger, actually was there on the rig. They were going to do the cement bond log. So BP had Schlumberger personnel on the rig in the days leading up to this, waiting to do the cement to do the cement bond log. And at the last minute, they decided they didn't want to spend the time or the $125,000 to do it, because in order to do the cement bond log, they would have had to shut the well down. They would have had to take everything out, put everything back in. There's a lot to, so they would have lost a day or two of time. And again, as I told you, at that point, every day really did matter. They couldn't afford to lose the day or two because they had to get to the other well. So the first thing they didn't do was do the log. Had they done the log, and you'll see a little later, the court found, had they done that test, that would have showed them the cement wasn't set properly, probably, and we'd have been done. This wouldn't happen. So that doesn't happen. The next thing they do then is they do a pressure test of the well. The second mistake in this case that they made was they didn't follow traditional negative pressure test procedures. Instead, shortly before they were set to do it, a BP engineer named Brian Morrell drafted a new set of procedures that were not standard, and he didn't share them with BP and Transocean in advance to give the engineers time to go through them and to decide whether they were proper or not. Turns out they, spoiler alert, they weren't proper. They didn't, and they again, as you'll see in a minute, negative pressure test fails. So that's mistake number two. Had they followed the traditional negative pressure test, that the traditional model, likely the pressure test would have showed correctly that the well was flowing, that it was not sealed. The third mistake that was made was in doing the negative pressure test, you have to move the fluids around in the well that are in the pipe, and you start with drilling fluid. You have drilling fluid in the well, and what you have to do is you have to pump some of that out, and you have to put water in place. And in order to keep, if you think about in your own mind like a garden hose, and imagine you're filling the garden hose with oil, and you're thinking about trying to push oil out, but you only get in there halfway. Now you got to push out the rest of the oil out with water. But if you start thinking, well, wait a minute, the oil and the water are going to mix, so that's a problem. Well, how do you get around that problem? Well, what they do is they put what's called a spacer. So they put another material in between the oil and the water, and it's a material that doesn't mix. It doesn't mix with the oil, and it doesn't mix with the water. And so it's almost like a plug, if you think about it, but it's another chemical. So now, again, in your garden hose, you put the oil in, you put the spacer in, now you turn on the water, and the water pushes the spacer, which pushes the oil. And on the other end of the hose, the oil comes out first, then the spacer comes out, then the water comes out. Okay? This is how they do it. In this case, instead of using traditional spacer, up in the days before when they were finishing the drilling, they were having problems with the bottom of the well, with a down hole, with leaks into the formation. The formation was not stable. And so as you're pumping the drilling mud down, you want to be getting as much drilling mud coming back up as you're putting down. And if you're not, that means that the fluid is actually flowing into the ground underneath. That's bad. Too much of that, you can damage the formation. You can also have, believe it or not, what's called an underground blowout, where you have a blowout of the well, but it happens underneath the ground, which can be very damaging to the environment also. So when you're losing fluid, what they do is they pump what's called a lost circulation material down hole. And it basically, you add to the drilling mud this material, and the material, when it's pumped down to the bottom and it gets out into the dirt, it basically clogs the dirt. So it basically fills the holes and then allows you to keep drilling, okay? So in the days before the incident, they had made up a whole bunch of this lost circulation material, and they had it on the rig because they were having these problems. They never used it. Well, now they have to decide what to do with it. The regulations allow anything that is biodegradable, they can dump offshore. They can dump it into the water, into the Gulf of Mexico. If it is synthetic, however, if it's oil-based or things like that, or dangerous to the environment, you can't. You have to actually pump it back into a boat, transport it back to shore, and it has to be destroyed or dealt with in an environmentally safe manner. The lost circulation material that had been made up in this case was that type of material. It was a synthetic material. It was not something that they could destroy dispose of by dumping it offshore. So they would have had to spend the money to pump it onto a boat and have the boat take it back to shore. So somebody got the bright idea at BP to use the lost circulation material as a spacer. It is somewhat similar. The materials are somewhat similar, but they're not identical. And to my knowledge and everybody's knowledge, no one had ever used lost circulation material before as spacer. So again, to save a little bit of time and money, instead of mixing up the right material, this spacer material, and using it, they used another material that was already existing that they thought was comparable and would serve the same function. Again, that was a mistake. The negative pressure test is conducted, the first one, and it actually shows that the well is flowing a little bit. But BP discounts those results based on a number of factors and believe that that's a mistake because they're confident, they are overly confident in the cementing operation based on history. So they decided to do another negative pressure test to confirm, and this time the negative pressure test gives them two inconsistent results. On one pressure reading on the drill pipe, it shows that the well is flowing, but on another pipe called the kill line, it shows there's no pressure. They explained away the pressure on the drill pipe reading on something called the bladder effect, which, without getting into it, was something, again, novel. Many people in the case, had never heard of this before as we got into it, litigation experts, et cetera. But some of the people on the rig believed that they had experienced that before in other drilling operations, and that was the reason why they couldn't explain why they were getting reading a 0 on one pipe and a positive reading on the other. They should both be the same. They should either both be 0 or both be showing flow. You really can't get one and not the other. So again, unfortunately, instead of believing the drill pipe showing that there was flow, they believed, I think probably because they wanted to believe, they believed the kill line. So they declared the negative pressure test a success, and it wasn't. The negative pressure test was telling them that the well was flowing, but they believed that the test showed that the well was dead. So that was a mistake. The next thing they did was because they believed that the well was dead, they started pumping out the drilling fluid and replacing it with seawater. You don't leave the drilling fluid in the well. Once you kill the well, once it's cemented in and you're done, you don't leave drilling fluid in the pipe, 15,000 feet of pipe. You take it out, and you actually, believe it or not, you put seawater in there, and then you close the well off. The problem with doing that is drilling mud is very heavy. The weight of it as material, and drilling mud is the first line of defense to a blowout. Drilling mud is your primary barrier for well control. So if you think about, again, a well being drilled, there's always, once you hit the pay zone, the oil and gas at the underground want to come up. So their pressure is trying to push them up the pipe. Okay. So the question is always, what's keeping them from coming up? It's the drilling mud. The drilling mud is heavier and is pushing down. Okay. And there's a lot of science that goes into weighting the drilling mud, so that you're always measuring, and then you're always adjusting the weight of the drilling mud. And they add material to the drilling mud and they remove material from the drilling mud to keep this balance going, so that the drilling mud is always a little bit heavier than the pressure coming up. And that's what keeps it down. You've got this constant fight, and you're always trying to push down a little bit more than it's trying to push up. But seawater isn't the same. Seawater it just has one weight, and it's not heavy enough. And so because they thought the well was dead, and because they took out the drilling fluid, they removed the first level of defense. The seawater was not going to be, is not solid, it's not heavy enough, excuse me, to stop the flow coming up. It's not what it's intended to do. So that was a mistake. The next thing that happens, unfortunately, is they start getting at 2101. I think at this point we're on mistakes, quite frankly, 6, 7, and 8. There is a period of time over the next 40 minutes where they are getting readings on the rig of pressure increases. At one point in time, there's a Halliburton guy, one of these mud loggers, whose job is to sit and look at a screen and watch these lines going across. And he should be watching a line like a flat line, like a dead person. He should be watching a line that's going across just flat. The line, as it turns out, we know from the detail, is going up. It's starting to go up very slowly, but it's going up. Turns out he took a smoke break for 15 minutes and was not at his post when he was supposed to be. And so he was not there to read that there was a pressure increase. This is just one of many things that happened over this 40 minutes where they missed various signs that the well was coming up. So unfortunately, the first time that they had any indication that the well was, was flowing and was out of control was when they actually started seeing water and fluid, coming out onto the rig, what you're used to seeing on television, the blowout. That, I will tell you, is a huge problem. It's often too late to stop a blowout once that happens. What happens in an oil and gas well is, again, think about your 20,000 feet underground. The gas that's mixed with the oil is under tremendous pressure. And so you think about a gas bubble. So you have a bubble of gas mixed in with this oil at 20,000 feet. That bubble gets into the pipe at 20,000 feet and starts floating up. As it floats up, it starts to expand because it's under less pressure. Every foot it goes up, it's a little less pressure. And so the gas keeps expanding and expanding and expanding and expanding. And so that little gas bubble at 20,000 feet, by the time it gets to the surface, is a lot of gas. Meanwhile, as it's going up, because of what's happening, it's also accelerating. And by the time that gas comes out and it's pushing all the fluid out, it is accelerating at near sonic speed. And the men on the rig who survive will tell you, it literally sounds like a freight train coming out. I mean, the sound, apparently, I've never heard it, thankfully. Apparently, it is deafeningly loud, literally like you were next to a freight train, going, because with this coming out. Well, at that point in time, now the oil and gas are coming out. They try to divert the flow to go off, to get it off the rig with something called a mud gas separator. And a mud gas separator makes sense. It tries to separate the gas out, and it tries to push it offshore so it's away from the rig. Unfortunately, because it was too late, because of the volume, because of a number of other things that happened, didn't work properly. The gas very quickly started expanding. It was on the drill floor. And at that point, once the gas alarms go off, you're pretty much done. Any ignition source is going to light it. And in this case, we don't know what the ignition source was, whether it was a generator or some other thing, most likely a generator on the rig floor. But as soon as the gas hit something that was an ignition source, the well exploded. And that's
okay.
Yeah.
There's one question. Can I ask it real fast?
Yeah,
it has
sure.
to do with 18. So at 1800 hours, we have a question where it stated the gentleman accepted the bladder effect. Okay, so there's a movie, and some of us have watched the movie. So in the movie, it says that they did another test that had them bypass a portion of the kill line, and that gave an official 0 result. Is that factual? Did they actually do another test?
They really didn't do another test exactly. It was the test results from the kill line that they relied on. They manipulated it a little bit and did some other things with it, but they really never did another. I don't think really another test. what they believe may have happened, and that's why I talked about the spacer earlier. What they believe may have happened is that the spacer that was, pumped actually clogged the line, and so there was not. So you're supposed to have this, this fluid in both the drill pipe and the kill line, and what they believe is actually the spacer blocked that, and so you had different fluids and you had a clog basically, and that's why you got the two inconsistent results. But they did not do another test after that. They did test the bladder effect part. I should say well, it didn't come before. They did both. The bladder, what they did was, I think I take it back. I think what they did do is they shut the drill pipe off, and they checked the kill line again. So yes, it's not another test, but they did a kill line only, if you want to call it a test. So they basically discounted what was going on in the drill pipe. They said it's the bladder effect, so now it's a corrupted test, if you will. So they're focusing on the kill line. The kill line's reading 0. They shut off the other pipe to see what would happen with the kill line alone. The kill line continued to read 0. And so they believed that the kill line test was correct. So yeah, again, in a sense. And so they went with the kill line results. Those turned out to be the wrong results, whether because the line was clogged with a spacer, or, well, they really don't know what other explanation there could be at this point. So because again, it wasn't 0. We know for a fact that the reality was it wasn't 0. So the question is, why did it read 0? The only explanation that's plausible, for the most part, has been that it was clogged with this material that then when you put the pressure in, it caused it to read 0. So that's in a nutshell what happened, and we'll talk some other stuff in a minute. But it all starts with the cement job. The cement that they pumped was not stable. It was not proper. We're going to talk in a minute about it wasn't in place properly. In addition, but even with that, and this is why we're going to talk in a little bit later why Halliburton wasn't held more liable. Even with all the problems with the cement itself, it's the court and the government focused on these series of events after that as the real causes of the incident. Because again, at any one of these mistake times that I just mentioned, had they figured out that, cement jobs fail, I guess is where the government comes down with it. Even when you pump the right kind of cement and you pump it properly, every once in a while it doesn't set up properly, which is why you do all these tests after, and so you can't just say, here it's a little different because the cement really was crap that they were pumping. It wasn't the right, somebody called it shaving cream during the trial. At Cameron's lawyer, you kept calling it shaving cream. It wasn't proper, but regardless, had they done a cement bond log, they'd have figured it out. Had they done a traditional negative pressure test, they'd have figured it out. Had they read the negative pressure test results properly with the drill pipe and kill line, they would have figured it out. Had they not removed, well, at that point you'd figure it out. Had they then, after taking and putting in the seawater, had they properly monitored the well, they would have seen that it was kicking. And it's much easier, I didn't talk about this, but it's much easier to close in a well early than it is late. The lawyers love to talk, and the people in the industry love to talk about blowout preventers as being blowout preventers. They're not blowout stoppers. And that there comes a point in time where if the well is flowing too much, the blowout preventer cannot stop a blowout. It just can't. The pressure is too much, the flow is too great. And so here, it's these series of things, as I said, after that cause all the problems. There were a number of government investigations, as you would imagine, that came out of this. BP was ordered to do its own investigation. It resulted in something called the Bly report. A guy named Mark Bly was in charge of it. And it was pretty well done, actually, very detailed. But also the Coast Guard did investigations, various congressional committees did investigations, Chemical Safety Board, and each one of them issued their own reports. There are, if you Google it, there are probably a dozen different official reports going into great detail as what happened. What was interesting about this case from the get-go was the blame being placed among the three main parties. BP, Transocean, and Halliburton. As you guys know from most litigation, usually defendants in litigation tend to stick together. You know, you try to, you know, and the plaintiff's trying to go after everybody and the defendants stick together. That was not the case here. From the get-go, the parties were pointing fingers at each other. And I'm going to show you a video in a second here that just to give you a little idea, a little flavor of the relationship between the parties after this happened.
Lucas, I don't have any sound on this video.
Oh, is it not working for you all? Oh, crap. Well, do you guys not have sound for that? Shoot. Well, I'm gonna have to share it with you later. I'm sorry.
Check to see on the video itself if there's a sound on the video. Might turn that up. Maybe we can hear it. Nothing.
No?
No.
No, I'm sorry. I'll have to send it to you later. I apologize. It's a great clip of various congressional testimony where BP testifies and points the finger at Halliburton and Transocean. Transocean points the finger at Halliburton. Halliburton points the finger back at BP. Sorry, that's one of my best parts, best things to show you. Just to get through this quickly, because we have a limited amount of time, but there were a number of criminal charges brought in the case. BP pled guilty to various charges. Transocean pled guilty to various charges. Halliburton, as I said earlier, was found guilty of destroying evidence, but they weren't charged criminally for the blowout, which again I find very interesting. My biggest takeaway from this case, I have to tell you, is all of us were very surprised that Halliburton skated as well as they did. That the bulk of the liability went to BP and Transocean, because I really feel that Halliburton was much more responsible for this incident than ultimately they were found. Of course, the civil litigation was huge. There were lawsuits all over the country. Businesses, individuals, state, local, federal government agencies, everybody trying to collect everything from tax revenue, lost tourism revenue, business interruption, you name it. The cases were all consolidated in federal court in New Orleans, and the court held a 3-phase trial to determine liability and then damages. We've kind of talked about this, but at the end of the day, the court found that that Transocean drilled a little further than it should have, that there were problems at the bottom of the well and they should have stopped drilling earlier. It found that the cement was not placed in the right spot. The Weatherford tool that was sent down hole through which you pump the cement did not get placed properly and failed. And so the cement, as it's being pumped, instead of being pumped in the location where it was supposed to be pumped, wound up being pumped in a little different location and off center. And that's ultimately when it sealed up is one reason why the well didn't seal. More cement. Again, they were found liable for not doing the cement bond log, by not having Schlumberger go in and do the test at the beginning. So the negative pressure test, of course, was a big finding by the judge, that not doing the negative pressure test. And then the spacer, we talked about earlier, that using this LCM material as spacer, they were found liable for that it was unreasonable to do that, and may have led to the failure of the negative pressure test. And then ultimately the court found that BP was responsible for the blowout preventer not working because they did not maintain it properly, so that after the well blew out, when they tried to activate the rams to cut the pipe and close it, they didn't function. The blowout preventer never worked properly here. Without getting into much of the law part, at the end of the day, BP was found 67% liable, Transocean 30%, and Halliburton 3%. So that is the way the court ultimately went. And again, the biggest surprise to everybody was that Halliburton was found only 3% liable. That was given what they did, given the cement, given that the instability of it, the fact that they hid documents, destroyed documents, et cetera, pled guilty to that, for them to skate, the court basically found, not basically, the court again essentially found that although the cement was failed, it was a problem, it wasn't the cause of the incident, because it was all these superseding and intervening causes after that were actually the cause. And that's how they skated. It's pretty surprising, actually.
Hey, Lucas.
Yeah.
I do see one question. I think it's a question, but I'm going to go ahead and ask it just in case. One of the participants asked, was there enough of the rig left after the explosion to actually see the mud shooting out?
No. What happened was the rig was on fire, as I recall, for maybe 2 or 3 days. Eventually, it fell over into the Gulf, and they actually then had to sort of move it out of place because they had to try to get to the site to try to start capping the well. And so by the time they got to that point, once all that happens, the pipe breaks. It's flowing from underground. At some point in time, the pipe to the surface breaks, and so the well is flowing through the pipe in the water, and then eventually it's flowing at the bottom. Eventually it was flowing from the ground up. It was rising to the surface. So once the fire got going, probably in the very early, I mean, it's possible there's video from like within hours of the fire showing the oil coming up. But once it caught fire, and it blows up, it pretty much destroys everything, and you really no longer have the integrity, of the system, in operation. So. Anyway, as you guys can imagine, BP has spent well over $10 billion in penalties and fines and damages in this case, not to mention, incidental costs and stuff. They ultimately took a charge of $43 billion as a result of this incident. So it was probably the most costly accident also in the history of the world, in addition to the environmental impact. So, and then from settlements, just in case you guys are interested, Anadarko and MOEX, who were the non-operating partners, paid a little over $5 billion. Transocean and Halliburton, again, skated pretty well, I think. Paying $1 billion each under the circumstances was pretty good. Cameron wound up paying a little bit, and BP paid, Weatherford paid a little bit. And my client thankfully got out for zero. The court didn't find us responsible for although the spacer was at issue, we weren't responsible for, because it wasn't our decision to use the LCM as spacer. We made it up as LCM to be used as LCM. BP made the decision to use it in the other purpose. So real quick, I'll just show you a couple of quotes and stuff. So I know that you all had a presentation. I listened to a presentation a couple months ago from somebody talking about social media and other things, and I thought you might find it interesting to see. One of the biggest takeaways from this was being very careful and picking the right person to be your spokesman after an incident of this nature. Some of you may remember Tony Hayward, who was the CEO of BP. Tony Hayward turned out to be a guy who couldn't get out of his own way, and he sort of played the victim card with this for the first couple of months, and just over and over and over again, he said one stupid thing after another in public. And I'm going to show you a couple of them just for your amusement. Again, speaking to some executives, he's quoted as saying, "What the hell did we do to deserve this?" And again, this is in the backdrop of all these people being killed, all these people being seriously injured. Oil at this point, as you know, is flowing, and just historic amounts into the Gulf of Mexico. And he's quoted as saying, "What the hell did we do to deserve this?" BP. Another time he's talking about, the Gulf of Mexico is a very big ocean. The amount of oil and dispersant we're putting into it is tiny in relation to the total water volume. Again, it's sort of an excuse, like, this is no big deal. At the end of the day, it's just a little oil, Somebody asked him if he sleeps well at night. He says yes, and then the chairman, piles on with I hear comments sometimes that large oil companies are greedy companies or don't care, but that's not the case with BP. We care about the small people. I mean, it's just, it's one of those things where small people, you can't, how stupid can you be, But the best, and maybe you guys might remember this, the most infamous thing Tony Hayward ever said was, I'd like to get my life back. He was being questioned about a month after the incident. He's talking about, I can't remember exactly what the question was, but he says to the reporters, there's no one who wants this over more than I do. I want to get my life back. He was crucified for this, for those of you who may remember, in the media. Again, in the face of all these other people who died, injured, again, all these people whose businesses are being ruined, the environment being ruined, and he wants his life back. I mean, you can't say something that stupid and be that, you know, at that level. I mean, it was shocking, actually. I still remember it. I was going to show you, I guess let me see if this video will play for you, because this is a really good one. Can you hear that one? No? No. Okay. You'll have to watch this later. So this is a video. This is going to be my big thing for you guys to watch. So this is a Saturday Night Live type video post-incident where they're making fun of BP for the incident. And when you see this, you guys have to click on it. If you do nothing else, watch this. It's 5 minutes of hilarity. It's about a coffee spill on the table at BP's headquarters, and they go through days of how to deal with the coffee spill, and it's a whole parody of what happened. So unfortunately, my big finish, that was my big thing for you guys, and I can't believe I didn't know that the audio wouldn't work. I'm going to end with 4 other just emails for you guys. So obviously the other big takeaway, as you guys know from lawsuits all the time, is emails can kill you. I mean, you know what your people put in their emails is never good. It's almost always just horrifically damaging. This case is no different. This was the perfect case for plaintiffs' lawyers. These oil rigs, as you know, are offshore. They're hundreds of miles offshore. They're dealing with people back in Houston or in other locations. And so all day long, their emails going back and forth. It's how they're communicating with each other. So it's just this wealth of communications back and forth. These people, I'm going to show you some of these emails. So this one was referred to during the case as the Jesus email. So Bobby Bodek was a BP geologist. This email is about a week before this is about a couple weeks before the incident. And this is when they're having trouble with the well. I told you before they use these lost circulation materials to fix problems in the well. So they're having problems with finalizing the drilling operations, right? And he writes, I'm going to get the rest of this well down with no more SSNP. And then I'm going to walk on water back to land, bitch. Thanks, Jesus. You know, obviously, in retrospect, he's talking about what turns out to be a very serious issue, a preview of potential problems that are coming, and you can imagine what plaintiffs' lawyers did with this email. The next one is a guy named John Guide. He's an executive overseeing the well from the shore, talking to a guy named David Sims, who's another executive on shore for BP. And again, this is 3 days before the incident. They're talking about problems they're having, again, with finalizing this operation. And Guide is complaining about what's going on at the rig, that with the personnel. And he's talking about flying it by the seat of our pants. And he says, Brian has called numerous times trying to make sense of all the insanity. Last night's emergency involved 30 barrels of cement spacer behind a top plug and how it would affect any bond log. And he says, I do not agree with putting the spacer above the plug to begin with. So they're talking about the spacer. They're talking about whether or not to do the cement bond log. Guide was one of the people who didn't want to do the spacer in the first place. He's actually the only person but he wasn't in a position to veto the decision to use the LCM material as spacer. The other guy responds back to him and talks about how he's got to leave for dance practice in a few minutes. As I recall, his daughter had some kind of dance practice. So basically, that was more important to him than this. And at the very end, he ends his email by saying, "We're dancing to the village people." You can imagine what plaintiffs' lawyers did with this email. The next one, again, 4 days before the incident, this BP drilling engineer is talking about doing the cementing job. They're having trouble. If you can imagine, you're putting this pipe 20,000 feet down. When it gets down to the bottom, let's say you've got a a tube that's maybe like 3 feet around. It's not quite, but let's just imagine that. And you're putting the straw in the middle of it. You're going to pump the cement. You want that straw to be centralized. You want the cement to come out evenly around all the sides. So they have these centralizers. They're having trouble with that and figuring out how they're going to do it. And Cocallis' response to the issue is, who cares? It's done. At the end of story, it'll probably be fine. Of course, it turned out it wasn't fine. Because they didn't centralize the pipe, the cement, again, part of why the cement didn't go in the right spot, left some spacing and allowed the oil to come back up. So again, you can imagine what the plaintiff's lawyers did with an email that says, who cares? And it, we'll roll the dice. The last one I have for you is another BP geologist, again, Bobby Bodek, who says, this is, again, a month before, he's under pressure to finalize the drilling, because again, they got to get it moving. And he literally says, if they want to push this next whole section to total depth, it'll be in God's hands. And they're talking about, again, the problems they're having at the very bottom and whether to go another 100 feet or so. Again, sending an email when there's an explosion that says in God's hands isn't very helpful. There's another one I didn't share with you because that's just the wording, but I'm going to end since I couldn't end with the other one. There's another one where there's a young geologist for BP on the rig. And he's really cocky guy. And as they're going through some of these operations, he does something he thinks is really creative and ingenious. And he sends an email back to his buddy at BP back on shore. And he ends his email by saying, I am the effing man. So he doesn't say effing, okay, man. And I'll never forget, I wish in the right circumstance, I would play the video of the plaintiff's lawyer, who's a very good plaintiff's lawyer, deposed him for probably 7 hours. And I bet you at least 20 times, he would ask the guy a question, the guy would give an answer, and the plaintiff's lawyer would follow up with, and that's because you were the effing man, right? That's over and over and over again. And again, they played that for the jury, for the judge in the trial. You can imagine the impact. So, again, as you guys know, emails can kill you. They always do. Well, I apologize, but my two best things to show you were the two videos. So I'm sorry about that technical difficulty. But if y'all have any questions, I mean, normally when we do these presentations, we talk about this case for 3 or 4 hours because, as you can imagine, we get into a lot of lessons learned from this, both from a drilling standpoint, from a crisis management standpoint, from everything from your public spokesman, your emails, I mean, you name it. I tried to pick just some of it for you, but I'm happy to talk about this as long as anybody wants to visit about it.
Lucas, I do want to make one statement, and then I want to follow that up with one question that we skipped over on accident. So one of the participants wants to make sure that she gets a copy of the presentation. I would love to see those videos myself. So if you wouldn't mind, if you can please share that presentation with Jennifer or myself. I think you have her email.
Yeah, I will. I'll send it to you. Yeah.
And we will distribute those out to anyone who asks. That would be wonderful. And then the question that one of our other participants had was, how long did it take for the crew to cap it? Didn't it take days?
It took 3 months to finally cap the well.
Wow.
Almost 3 months to the date. It was July, I want to say it was like the 15th or something like that, before they finally figured out they had to remove the blowout preventer. Was actually on the ocean floor, on the Gulf of Mexico floor. And it's not the kind of blowout preventer if you've ever seen an oil and gas well, I would have only seen them on shore. It's not that kind of blowout preventer that's only maybe as tall as this room, 7-8 feet. The blowout preventers in these deep water environments are literally 4 and 5 stories tall. They're huge because, again, you're dealing with these tremendous pressures and stuff. And so they had to when they tried first thing they tried to do was to activate the BOP, other bunch of BOP. They had trouble with it. They were trying to electronically see if they could make it work. So that was stage 1. When that didn't work, they had to spend time actually removing the blowout preventer from the wellhead so that they had a free space. Then it was they tried various other pieces of equipment to try to put onto the wellhead to lock it in. And again, as you can imagine, that's not difficult to do with the fluids coming out. The other problem you have is you can't just instantly close the well. The pressure at this point now, you've got all these pressures and it's flowing. And as I mentioned earlier, believe it or not, there is a concern about what's called an underground blowout. If you seal in the well too fast and you don't control the pressures, you could basically create a bomb underground, which could explode. And now the formation is flowing into the soil underground. It's flowing underground. There were environmentalists who believed that that would have created long-term a much bigger environmental catastrophe than, believe it or not, the flowing up. And at one point in time, believe it or not, they were actually debating whether it was more prudent to just let this thing flow till it was done, because there was so much concern about the underground blowout that if that had happened. So what they wound up doing ultimately was they manufactured this type of blowout preventer or type of a wellhead, put it on, and then over a period of time slowly closed in the well by reducing the pressure. They also built a relief well. They drilled a relief well that allowed for some of the pressure to release. So it was a combination of things, but it took a lot of time. There were real concerns that they were not going to be able to get this well under control, or that the control methods that they might employ could actually be worse for them than if they did nothing, believe it or not. Because there are environmentalists who will tell you that eventually the oil, even if in the Gulf, as you guys know now, fast forward 10 years, there's no more oil, you don't see it washing it up on shore. Believe it or not, it disappears. The oil, there are microbes in the water. There are, the oil eventually disperses. The heavy oil sinks to the floor. It does go away. And so anyway, that was a big issue. There were, I can't tell you how many different solutions that they considered, and how much hand wringing went into that, because they were so concerned about failing and making the situation worse than what they had.
This is fascinating. I actually followed up on this story a lot, working at Neal and Harwell and having somewhat of a direct association with this case. There are 2 more questions. If anybody needs to go to return back to work, you are more than welcome to. You don't have to stay and keep participating. If you do wish to stay, we can follow up with those questions. Lucas, there are 2 additional questions. So one, did Halliburton have any other lawsuits or cases pending against them regarding the unstable cement?
Well, they were a party to all of the litigation, the civil litigation in here. I'm not aware of them being sued, like, totally unrelated to Deepwater Horizon. I'm not aware of them being sued in that capacity. But they were a defendant in these thousands of cases that were filed, that were consolidated in New Orleans federal court. BP, Transocean, Halliburton, Cameron, us, were all parties. So Halliburton was sued in all of those cases. Halliburton and Transocean ultimately were able to avoid paying in the civil cases because their contracts with BP provided that BP would indemnify them for anything that happens on the rig. And one of the findings that the judge made in this case was that the indemnities were enforceable. And so BP really got stuck paying the bill here. There are reasons for that. I mean, it's unfair in this case on some level, but in the big picture, again, for drilling operations, the operator, when you're drilling a well, BP in this case, they are the party who has the most money going in, and they're the party who's going to make the most money, and they're involved in the overall process. A company like MI, in my case, MI is going to get paid a total of, let's say, $500,000 to do all of its work on this project. Well, as you can imagine, we can't somehow insure against $1 billion, accident, making only that much money. And imagine some of these other people doing even less, like Schlumberger with a cement bond log, $125,000. Well, you'd have to charge. Imagine the insurance premium if you were the one who had to cover the insurance for risk of loss to the well. Okay. And so contractually in the oil and gas industry, the parties put that burden on the operator generally, because again, they have the money on the front end. They're in charge over all of the drilling operations, and they're going to make all the money on the back end when they start pumping the oil. So what happened here was Transocean and Halliburton had some pretty detailed contracts, and in both cases they shifted the responsibility back to BP, and BP wound up eating it, in the end.
We have one more question, and then we're going to have to close it. I know it's storming here, and there's lightning as well. So, and I think at one point your communications were kind of being interrupted a little bit. But last question: if the rig was destroyed and fell into the Gulf, how was it done?
How was it what?
How was it done? If the rig was destroyed and fell into the Gulf, how was it done?
I think they're talking about getting the well plugged.
Oh, so they used a different rig. They moved other equipment on site.
How was the capping done? Okay.
Yeah, they used other equipment. So the Deepwater Horizon itself, it's basically, it's basically a big boat. I mean, it's a huge, so once it capsizes basically and goes under, it's gone. So they brought out 2 or 3 rigs out there. I can't remember the name of it now, but they brought another rig out that was right there, and they brought another one, I think, pretty close, that was drilling a relief well, and they had all kinds of other equipment out there. So it was not using that rig. They brought another, I think Deepwater, Transocean brought another rig over. Yeah.
Wow, fascinating. Well, if there are any other questions, well, I see one more. So there was a ship off the side of the rig. Why did that ship not have any safety features that could assist with putting out the fire? But I think you kind of touched base on that question just then. It was there.
At the time of the incident, at the time, the ships that are there they're not fire equipment. They're not for fire. The ships the different boats, they're either supply ships coming and going, or they're basically storage vessels. They could have fluids on them as for extra storage that they're going to be using on the rig. Or again, you could be pumping fluids off the rig onto the boat, things like that. But they're not fire equipment. They don't do that kind of they don't perform that. Yeah.
Well, if anyone else has any other questions, you can unmute yourself and ask that question. Otherwise, if anyone needs a copy of the CLE certificate, please be sure to email Jennifer. Once again, her email is jennifer.mustaine@wallerlaw.com. If you guys have any other questions, please feel free to follow up with us. And I see that Kelly does have a question. Go ahead, Kelly.
I really don't have a question. I just want to thank you, Lucas. This was fascinating.
Well, my pleasure. Like I said, we can spend a lot of time. You can spend hours on this. But the actual PowerPoint I have that we use for this, as you can imagine, is much more detailed and goes into a lot more. And I feel really bad because my 2 videos were my best part. So I'm like,
Well, I can't wait to watch those.
Yeah.
Another thing that we can do too, everyone, is that when we post this recording to YouTube and to Facebook, we'll try to also post a copy of those videos and attach those somehow. So we'll try to follow up and get that information out to everyone. Thank you so much again, Lucas, for joining us today. We hope that you will consider coming back and being a guest speaker for us again. And we hope that everyone has a safe, wonderful day. Thank you so much.
My pleasure.
Thank you.
Thank you.
Thank you. Bye-bye.
Y'all take care.
You too. Thanks. Bye-bye.
Is there anything that anybody else needs to talk to? Hi, Denise. Oh, we can't hear you. You sound like a mouse. Can't hear you. Jennifer, can you hear her?
I can't.
And I see there's one more person left as well, 11602.
I'm going to put them in the waiting room. Okay. I'm not sure who that is.
Denise, maybe unplug your headset. Can't hear you at all.
So I saw your chat. It says, I wanted to know how this matter ended up in New Orleans. What do you mean by that? I mean, it kind of, the oil went all the way over like Pensacola. Oh, the lawsuit, maybe.
How it had jurisdiction there?
Yeah.
I think I recall that it ended up having jurisdiction there because there was so much conflict of interest for the judges who were closer. They had to, yeah, they had to renounce themselves and remove themselves from the case because it was so close to home. So they had to go further down south. I think I could be wrong, but I think that's what I remember hearing.
Yeah, that makes sense.
That's a good question. All right.
All right.
Hi, Denise. And we can go ahead and end the recording as well.
Yes.